Car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis, Wright, and host David Lamb.
Welcome back into the attorneys. Great to see you again tonight. Thank you so much for joining us. For the next half hour, our topic of conversation is workplace harassment. You know, whenever you're doing a job or a career that you love, there's nothing like going to that job and that sense of fulfillment. But whenever that workplace, whenever you're getting harassed and you dread walking through the door, what are your rights? And what do you need to know to help improve that situation? That's our topic of conversation tonight, and we would love to have you join us in this conversation. You'll see throughout the program ways you can call, text, email. Also, an attorney is standing by even as we speak. Would love to talk to you right now, so please take advantage of that as well. Josh Wright of the firm Hollis Wright leading our conversation as he often does. Good to see you, sir.
Good to see you too. Hope you had a great week.
I did indeed.
Once again, we come back into a new topic.
We do? Yeah, this is one we haven't covered, huh?
Well, we've covered it maybe once before, but we're going to put some extra spin on it today. Mitch Allen with Shunnarah Injury Lawyers is with us today. Mitch is a great lawyer in this area. He truly is an expert in this area. And as we talk about a lot of times, there are shows that don't fall into the wheelhouse of what we do as a law firm, but are important for the viewing audience to understand the law. And retaliation and protecting yourself in the workplace environment is one of those. Some of the statistics, just kind of getting into this topic in preparation and pre-production, in 2015, there were some 2,000 retaliation cases filed in Alabama alone, which accounts for almost 50% of the total cases filed with the EEOC. And we're going to talk a little bit about the EEOC and the process and the things you've got to go through to file these cases. So first of all, Mitch, thank you for being on the show.
Yes, sir.
We thank you for bringing your expertise here and being able to answer questions to the viewing audience on issues related to retaliation. How did you get into this area of the law to start with? Because this is a unique little specialty in the legal world.
Well, actually, I've been practicing law for 27 years. I can't believe it's that long, but 27 years, and I started practicing at the biggest law firm in the state, and I defended cases of harassment and retaliation and for about 21 years, and have been representing individuals in these cases for about the last 6 years. So a lot of experience on both sides of the coin on this, so that's how I got started.
As we kind of start the topic, we have done shows on harassment, which is a little unique to what we're talking about tonight, which is retaliation. How do you delve into that area of the law too? Discrimination, harassment, those types of things. Is that something you also do?
I do. Actually, most of these cases initially start off as a discrimination or harassment case. Basically, someone will make a claim against their employer that they've been discriminated against or harassed in some way. And typically what it will be is it'll be a race claim, race discrimination claim, some sort of sex discrimination claim, a sexual harassment type claim, and then the employer will get notice of that claim either through the Human Resources Office or maybe they've made a claim through the Equal Employment Opportunity Commission, the EEOC, and when that claim is made, the employer will then take some action against the employee to retaliate against them for making the claim. So in order to basically have a retaliation claim, you have to have some sort of underlying harassment claim.
Now, we throw this term around a lot that in Alabama, employees are at-will employees unless they're subject to a contract for employment. Can you kind of dissect that just a little bit? Because we throw that term around a lot, but we never really do a great job of explaining it. If you can kind of explain it, I think it'll help.
Sure. In Alabama and in most southern states, we kind of call it the SEC, most southern states are employment at will states. And what that basically means, Josh, you're right, is that you can be terminated for a good reason, a bad reason, or really no reason at all, as long as it's not an illegal reason. And you know, it really is basically at the discretion of the employer. They have the discretion to terminate their employees as long as it's not for an illegal reason, something like on the basis of their race or the basis of their sex, or in the case of retaliation because they've made a claim of some sort of discrimination or harassment and then they retaliate against them. So that would be an illegal reason. But otherwise, in Alabama, if you are just an employee or an employee at will, and unless you're someone who has an employment contract like a Nick Saban or somebody like that, which most of us don't. I know I don't. Then you're going to be an employee at will.
Yeah. What's kind of the secret sauce in being able to kind of prove and defend yourself whenever you're having to prove some sort of harassment or any sort of kind of a pattern of behavior that makes the workplace untenable for you?
That's a great question. You know, in terms of these claims, you have really two ways of proving them. When we pursue these claims in court, when we litigate these claims, there's really two ways to prove these claims. There's what's called direct evidence, and then there's circumstantial evidence. Direct evidence is something where you have evidence where the employer has admitted that they took some action against somebody, either verbally or maybe in writing, that they took some action against somebody because of their sex or because of their race or because they were making a claim.
Right.
Those are pretty rare, as you would expect. Most employers are not going to come out and admit that what they're doing is illegal.
Yeah.
So most of the cases that we pursue, you'll have to pursue them under a circumstantial evidence approach. But you know, with today's world, with cell phones and with the technology that we have, and people are pretty smart out there. So we're seeing more and more direct evidence cases based on, for example, recordings.
Really?
Where people go in and they'll sit down and they know they're going to have a meeting with their boss, and they feel like maybe their boss is taking some action against them that may be illegal. And you know, in Alabama, it's perfectly legal to record a conversation with someone else as long as one of the parties to the conversation knows it's being recorded.
When we come back, I want to talk about protected activity, because that is a buzz phrase that is necessary to be successful in a retaliatory discharge case, and we're going to talk about those things.
All right, we'll step aside right there as we head to break. A reminder, an attorney standing by right now to speak with you. Take advantage of that opportunity. There you see the number, call, text, email, standing by right now to speak with you. Also, you can find the firm on Facebook as well as Twitter. Be sure and check that out. Just search the term Hollis Wright to find the firm on Facebook, and on Twitter it's Hollis_Wright. Stay tuned. More of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, you can call, email, or text us. Or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys.
Welcome back into the attorneys, workplace harassment and retaliation, the topic of conversation. We'd love to have you join this conversation on this subject matter, or maybe even something else. If you say, hey, I've got a question, I would love to get some legal advice on it, an attorney standing by right now. Those numbers are there on your screen, so take advantage of that. Josh?
Yeah, we had talked when we were going to break about the concept of what protected activity is. And I know, Mitch, you can probably explain this to the viewers. Not every form of harassment or retaliation is actionable. And when we talk specifically in the area of retaliation, you've got to be engaged in some type of protected activity, do you not, in order to be able to file a case?
Absolutely. There are a lot of things, obviously, that can happen in the workplace that an employee may not like. He or she may actually go and complain about that. the coworker may be, doing something that he or she doesn't like. He may have some strong cologne or perfume that he or she doesn't like. And so if you go to the management or HR office and you complain about that, that is a legitimate complaint perhaps, but it's not protected activity under the law. And if something were to happen to you as a result of that, for example, the boss liked that employee and liked the cologne and decided, I don't like you complaining, they could terminate you and there really wouldn't be an actionable claim for that. So yeah, it does have to be some form of protected activity, and that would involve a legal claim, a complaint about something. For example, you go and you complain about one of your coworkers sexually harassing you, or you go and complain about one of your coworkers calling you racially insensitive names or things like that, and you complain to HR about that or to the EEOC about that, that is legally protected activity, and if the employer then takes some action against you, that would be illegal retaliation.
Do you find sometimes that the retaliation claim value is even greater than the underlying conduct that contributed to it?
Josh, there is no question. We see cases all the time where the underlying discrimination or the harassment claim, it may be the employee has a legitimate good faith belief that there is something's happened to them, but there may be something behind the scenes or there may be some evidence out there that they just don't know about, which would substantially weaken their discrimination or harassment claim. But then the employer gets the complaint and they're so aggressively offended by that then they take some action against the employee for making the claim. I can't tell you how many times when I was representing employers where they would get a claim of harassment or discrimination, and they would call me immediately and they would say, I've just gotten notice of this claim, it's completely bogus. And they're offended by it. It may be a claim of racial discrimination, and they're offended. And the first thing they would ask me is they would say, we want to terminate this person because he's made this claim against us. Well, that would be then, the underlying claim may be completely without merit, but if they terminate them for making that claim, that would be illegal.
A lot of times, David, this comes up in the context of workers' compensation too, because that is a type of protected class, if you will, is workers within the workers' compensation statute, where if somebody files a workers' comp claim, they're allowed to do that, they're entitled to do that, and in fact, it's their exclusive remedy. They must do that if they've been injured. And if an employer turns around and retaliates against them and terminates them, there may be a retaliatory discharge claim that a worker has for being terminated for that reason. So it's very similar to kind of the concept that we're talking about.
There is an incident that's taking place, an event that is ripped right from the headlines. Colin Kaepernick, the quarterback, the backup quarterback for the San Francisco 49ers, he is making a political a stand or a statement, kind of a commentary on something that matters a great deal to him, and choosing not to stand for the national anthem. In fact, he sits for it. Can the 49ers fire him? Or how does that work in terms of, his employer is a football team, and the San Francisco 49ers, he's bringing certainly a lot of attention that they may not want. What if the owner of the 49ers is super patriotic and is offended by what Kaepernick is doing, as some are? I know there a lot of folks support him in that, but what if let's say the owner does not approve of that? Can he fire Kaepernick for what he's doing?
The political hot potato just got handed to you.
I was going to say, Josh, you want to take that one? That's
an interesting issue.
Yeah, it really is, and it's a great question. I'll tell you, and it's complicated. I don't know if there's a quick, easy answer for that, but I would say this, and it's already been discussed, I think, some in the media, as to the idea of, if a coach, they got 53 players on the team, and if a coach has a rule that he says, I want all 53 of my players to stand in attention, I believe in this country, I believe in this flag, and so he strongly believes, as you said, he's under an employment contract. He's one of those people that wouldn't be an employee at will, so there would be some complications to that. But you've already seen some of for example, one of the Olympic, I think it was the soccer coaches, that came out and said, that's a little different. You're not necessarily standing on the sideline kneeling down and not, when you're on the USA soccer team and you're not willing to stand up and give attention to the flag. So one of the coaches said, I know that player wouldn't be playing for me. Well, that I think we would all agree that is in some form or fashion some form of retaliation against that employee or that player for not doing what the coach felt was right. So it's a complex issue. It's complicated.
What if, where we might, can't relate to Kaepernick in terms of contract and all the money that, involved there. But what if I'm on a job and now the store opens on a Sunday, I'm super religious, can they make me work on a Sunday? If I go to church, if I'm a part of every Sunday, you hear folks, those kind of situations. Can an employer fire someone in a situation like that?
Well, a lot of questions depend on your religion and what your beliefs are, but there's been cases, that exact situation has happened where an employee has successfully brought a case, and so they are in effect discriminating against that employee for his or her religious beliefs. Right. And so that would be, under certain circumstances, illegal retaliation or discrimination.
I know we're getting ready to go to commercial break. When we come back, I want to talk a little bit about the damages that are applicable in these cases and what one can recover if they're successful in a retaliation case.
All right, we'll do that. We'll step aside our final break of the evening. If you have a question you'd love to speak with an attorney, the clock is ticking, so take advantage of that opportunity as we head to break. Stay tuned. More of the attorneys coming right back.
I'm Carter Clay with the law firm of Hollis, Wright. When someone whose unreasonable conduct causes an injury to someone else, the law says that person is negligent. So it seems the injured person should receive some type of damages, right? Not always so in Alabama. In tonight's Legal 411, we answer the question, what is contributory negligence and comparative fault? Alabama is one of only 4 states in the nation to withhold damages based on contributory negligence, meaning if you are at fault, even just a little, you cannot be allowed any damages in a case. For example, in a case where a defendant may be 99% at fault for hurting you, if you are found to be 1% at fault, Alabama law says you get nothing. 4 states, Virginia, North Carolina, Maryland, and Alabama, plus the District of Columbia, are the only places in the country where a defendant can completely avoid paying if the injured person is even 1% at fault. This is very different from comparative fault, the measure used in 46 states. There are 2 versions of this system, but both essentially allow money damages based on the percentages. For example, if the injured person was 20% at fault for causing an accident, then the recovery for medical bills and wages is reduced by 20%. Numerous studies across the country show that people who live in comparative fault states believe this system of justice is more fair. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will always respond to every question you send in. That's our pledge and promise to you.
Welcome back into the Attorneys, our final segment. So just a few minutes remaining. If you have a question you would like to get into our panel of experts talking about workplace harassment and retaliation, we'd love to have you join this conversation. Josh?
2 things. One, I want to talk about damages, but because I know there are people that are wondering what types of recoveries there are. Is there an administrative EEOC process required to file a retaliatory discharge claim, or is that generally reserved in circumstances when someone is filing a harassment claim? Because I know they're separate.
That's a good question. Actually, it depends on what type of law you're pursuing. If it's a federal discrimination or harassment claim, then you do have to go through the EEOC process. Typically, what we see, Josh, is there will already be an EEOC charge filed, or there will be a complaint made with the HR office. And so in order to pursue your rights ultimately in court, you would have to pursue first a claim through the EEOC. So
Probably a good reason to get a lawyer involved early.
absolutely. It for the most part, it is what I've seen. My experience is it's almost it's a mistake not to.
Yeah. Talk a little bit about damages. How does that work? If somebody has a valid and viable retaliation claim, how can they be compensated for that?
Well, there's a variety of damages available. Most people think that it just involves, one of the things that most people realize is back pay, which is if you've been terminated from a job and you were making a certain salary and that salary immediately goes away, then you can be paid that salary, and that's usually for a period of up to 2 or 3 years. You can also get, in some really egregious cases, front pay, which would extend to 6 or 7 years. One thing that a lot of people don't realize is one of the best remedies available in a termination case, a retaliatory termination case, is you can be reinstated. Now, a lot of people would say, well, they don't want to go back to that employment. They don't want to be reinstated, but that situation, just the fact that you could be reinstated is a big deal.
I know there's confusion a lot of times because we get these calls, texts, and emails from consumers and people watching the show about, I can't afford a lawyer. I don't have the resources to do that. And we talk a lot about contingency fees and how there are contracts in place where lawyers can represent and protect people without them having to come out of pocket. In a retaliation context, if somebody has a retaliation claim or they think they do, are there similar concepts that lawyers use from a contractual perspective to make sure that somebody doesn't have to come out of pocket to compensate the lawyer for their time?
Absolutely. The cases that we handle, we do represent folks on a contingency fee basis, which means any recovery that they have, their fees, their attorney's fees will come out of that recovery. The thing that is unique about this area of law that's different from other areas, I know the areas that we practice in a lot are personal injury and cases like that, but in the federal employment area, one additional remedy that's available to someone who pursues a claim and they're successful, they can actually recover attorney's fees from their employer. So their attorney's fees would actually be paid out of the recovery from the employer. So that's additional damages that they can recover, which is available.
Another good reason why you get counsel involved early, to understand that, to be able to maybe even in some contexts offset the attorney fees that are going to be required to pay through the contingency fee contract. So having a lawyer involved that understands that process, that can explain to you through the contracting process what you're going to pay, is helpful. And I have often found it helpful to explain to people that they get the same quality of service that the defense bar provides to their employers with a lawyer on a contingency fee contract if you go to the right firm, because you have the ability to have a full and complete investigation and evaluation and a filing done just like would be done on the other side of the bar. So having a lawyer that works on contingency where you don't come out of pocket in these cases would be very helpful.
If you feel as though your workplace is unhealthy, unsafe, you do not trust the leadership, why is it a necessary step? And oftentimes you hear that the first step you need to take is to let someone know. If you have no confidence in the leadership of where you work, why even take that step?
Well, first of all, in a lot of areas that we're talking about here, in order to maintain a claim later, it's going to be required that you at least raise the issue with your employer. For example, in the sexual harassment or racial harassment context, the law says that the employer has to know it's happening and be told of a situation, whether it's through the HR office or through a higher level manager. So oftentimes you're not even able to bring a claim unless you have gone ahead and let the employer know of the situation ahead of time so they can at least address it. Right. Oftentimes they don't, and then you go forward with your lawsuit. But it's actually a prerequisite or requirement to filing suit that you let the employer know.
And if you don't, there can be some consequences from a damages perspective?
There can be absolutely from a damages perspective and just the ability to maintain the lawsuit. You can actually file a lawsuit, get into the lawsuit, and the employer could actually have the case dismissed for that reason.
Just a couple of minutes remaining, but want to give both of you the opportunity just for some final thoughts to leave with our viewers tonight. And we'll let you, Mitch, go first.
Sure. I think just in terms of what Josh started the show with, which is in terms of just the number of retaliation cases that have been filed over the last, say, 8 to 10 years has risen dramatically, especially here in Alabama. And I think what that means is basically that if you think that you're in a situation where your rights are not being protected,
right,
address it with your employer. They will then have to do some sort of investigation into the claim, and whatever the investigation shows, it will show, and then you will go forward. But oftentimes what we see is the employer actually retaliates against the employee for making the claim, and then that results in the better lawsuit. So from my perspective, I think retaliation cases are on the rise, and for good reason.
Yeah, you know, the only thing I'd say is this is a special area of the law where not having counsel will be a catastrophic mistake. There are administrative hurdles that you have to go through. There is forensic evidence that you can capture before you ever file your lawsuit. We've talked about phones and recordings. There are things that you can do to protect yourself. You need someone to lead you through the process, and having a lawyer that understands the context of this law to protect you and to maximize your recovery is significantly important, even more so than a lot of areas of the law that we talk about where you could go it alone. This is just not one of those areas. So a guy like Mitch is a guy that you want to go to, and Mitch, thank you so much for being on the show.
Appreciate
you did a great
it.
I enjoyed
job.
it. Thank you all.
Very helpful.
Really interesting conversation tonight. Hope you enjoyed it as well. Thank both of you for being with us, and we appreciate you being with us as well. Attorneys, continue to stand by if you have a question for them. We'll see you next week right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.